Welcome everyone to the Family and Wills Trust and Estates Law Challenges and Solutions for British Columbia Legal Practitioners webinar. Okay, so I'm actually going to start off with introducing two special speakers today. I'll actually introduce myself first. I'm a lawyer by profession and a practice area consultant at LexisNexis Canada. And please welcome Georgialee Lang, who's an arbitrator and appellate counsel litigation strategist at Georgialee Lang Law, and Gordon Behan, who's a partner at Clark Wilson LLP, who practice estates and trust elder law. And I will actually go through the agenda for today. We're going to be discussing a couple of different things today. We're going to be discussing the family law regime and history. We are going to be discussing discretionary trusts and conflicts between that and family law. And we're going to be discussing a specific case today, which both Georgialee and Gordon will be going through the case summary of the facts. There will also be a legal analysis and outcome of the case that we discussed. I will also be doing a Lexus Plus demo of the case, and we'll do an audience pool question and a question and answer. So let's start off with Georgialee, who's going to be discussing the family law regime and history.
Thank you, Tina. So how did we get to where we are today? Well, the first considered decision on discretionary trusts was decided in 1987. So that's almost 35 years ago. And it was the case of Whittall versus Whittall. And that was the first case that looked at a discretionary trust. Of course, that case was assessed under the definition in the Family Relations Act. And the definition at the time was that an interest in a trust owned by a spouse could be a family asset. So that was the description, an interest in a trust owned by a family asset. There was no differentiation between a fixed trust or a discretionary trust. And when the court looked at that case that many years ago, they determined that with that definition, an interest in a discretionary trust was a family asset. The issue was not one of entitlement, it was one of valuation. And they determined that they would rely on other law that had developed in British Columbia with respect to pensions. So if a spouse had a pension, but the pension wasn't vested, but they had an interest in a pension, the court said, if and when the pension is payable to the spouse, that spouse will have an obligation to be a trustee for their spouse's 1/2 interest. And that's the analysis that the court used in Whittall. They said, this discretionary trust is a family asset. And if and when the spousal owner acquires an interest down the road, that will be divided and the spouse who is the owner will be a trustee. Now, that was a simplistic way to deal with this complicated issue. Of course, one of the frailties of that was how on earth would there be any reporting power? Typically, spouses don't remain in contact unless there's children. And so there would really be no way for a spouse who was in the position of being a beneficiary to obtain an interest. But that hasn't stopped the courts, because the most recent case that cites Whittall is the BC Court of Appeal. And that's a case that's called HSS versus SHD. And that case was decided in 2018. And the BC Court of Appeal, once again, this is under the Family Relations Act, they once again relied on Whittall, but there was a slight twist in this Court of Appeal case, and that was the trust had been a discretionary trust, but the trustees had wound up the trust and had divided the trust property between all the beneficiaries. So the trust interest of the spouse now was a fixed amount. And the court held that because it was a fixed amount, it was easily quantified, and the spouse in this case was given a share. And the Court of Appeal also said that if there's a certainty that trust assets will be transferred to a beneficiary, then of course there is a claim, and the quantification is relatively straightforward. You need to know, though, that when the government of British Columbia repealed the Family Relations Act, they enacted the Family Law Act. And the first go around in 2013, they defined discretionary trust with some more complicated amendments. However, within a year of that legislation becoming law, they recognized that they had made an error. And the error that they made was that they still were referring to trust property being divisible, even though the law was clear under the Family Law Act that a discretionary interest in a beneficial trust, in a discretionary trust, does not give the spousal partner an interest in the property, but a beneficial interest in the discretionary trust. And so that was corrected in 2014. And so the legislation now is found in the Family Law Act and is quite detailed. And when we come to discuss Cottrell versus Cottrell, you can hear more about how the court now has evaluated and assessed those provisions. Thank you, Tina.
Thank you, Georgialee. Now we're going to have Gordon discuss the discretionary trust and conflict with family law principles.
Yeah, so thank you, everybody. I'd like to take a couple minutes to talk about this issue from an estate and trust perspective. And in doing that, I'm considering the question of what is a discretionary trust and how do its principles relate to or conflict with family law principles. And so I think it's important to start with remembering a trust is not property. It's not something like a bank account. It's not a separate legal entity like a company. It's only a relationship. And so in that context, property is contributed, as you know, by a settlor. It's held on terms by the trustee or trustees, and it's held for the benefit of the beneficiaries. And that's the relationship that involves property, but it's itself not property. As you all know, there are various types of trusts settled for various purposes, such as tax planning and estate planning. The trust document itself sets out what the trustees may do with the property. And for our purposes, we're particularly interested here with discretionary trusts. And so with a discretionary trust, the trustee holds the property for a class of beneficiaries and has complete discretion. And this is very critical, complete discretion as to the payment or income, payment of the income or capital to the beneficiaries. And depending on the wording of the trust, this is also important, a trustee can favor certain beneficiaries over other beneficiaries. And so that means if you're a beneficiary of a completely discretionary trust, there's no guarantee that you'll receive anything from the trust at all. It's merely something you may receive. And there are various ways in which a beneficiary may not receive anything. The trust could be wound up prior to their receiving anything. Funds could be distributed out to the exclusion of that particular beneficiary. And some trusts even permit a beneficiary to be removed from a trust. And so all of that could happen in addition to some other ways. And so including that some trust interests and the increase in the value of trust interests is family property brings into conflict these concepts from trust law with the equity and fairness in dividing family property. And so when a spouse is a beneficiary of a discretionary trust, that spouse doesn't have the right to demand a distribution from the trust. There's no proprietary interest in that trust property. The beneficiary only has the ability to ensure that the trustee is exercising their discretion properly. And so considering that, the value of an interest in a trust, a discretionary trust, is very difficult to determine, if it can even really be determined at all. As I alluded to earlier, as a matter of trust law, an interest in a discretionary trust is a mere hope, just a hope of receiving a benefit, and really cannot be valued. Yet the family law mandates that some sort of determination is made, and that's the issue that the courts are currently working through, as we will discuss. And so with that, I will turn to the Cottrell and Cottrell case. It's a very recent decision from Mr. Justice Brongers, who has written several recent cases actually touching on estate and trust principles. And so in this case, he's dealing with valuing the increase in a spouse's beneficial interest in a discretionary trust for the purpose of dividing family property. So I'll set out the facts of the case, and Georgialee will discuss the outcome and legal analysis. So here are the key facts that I think you need to know to understand the case. It involves Paul and Joanne, who started a relationship in 1994. They were married in 1995 and ultimately separated in 2017. They were granted a divorce in 2021, but there are several other legal issues that remained between them. Paul had worked as a marine biologist. Joanne was primarily a stay-at-home mother to their two children, and the children were both adults at the time of the legal proceedings. Prior to Joanne and Paul ever meeting, Joanne's parents, who were referred to as the Musters, won about $5 million in a lottery. And with that money, they established trusts for their two children. They did gift funds to their children, Joanne and her brother, through the trusts over the years. These were previous versions of the trusts. And so some particular examples in respect of Joanne, she received $50,000 in quote unquote fund money after the lottery win. The Musters gave each of their children approximately $500,000 through the trusts, which their parents, which the parents, the Musters, controlled and managed. And so that was every 3 months, they would distribute about $5,000 to Joanne through the trust. In 1991, she received $190,000 through the trust to buy a condo in Burnaby. And she had $178,000 on deposit at a personal bank account that she received when this particular trust was wound up. So there was a history of her receiving some funds. In 2010, the Musters reorganized their corporate and trust assets, and they settled two new trusts. These were the Family Trust and the Joint Partner Trust. And just viewing these collectively, they were discretionary trusts, and the beneficiaries were Joanne, her parents, and her brother. Her parents were the trustees. And it was assets that derived from that original $5 million lottery winnings. It was investments and savings. After Mrs. Muster passed away in 2012, Mr. Muster added Joanne and her brother as trustees. There was evidence given about this, and Mr. Justice Brongers accepted that Joanne was not active in managing the trust. And that evidence was given both by Joanne and Mr. Muster. Around the time of her mother's death, Joanne received monies from the trust, which she placed in her personal bank account. I talked a little about that earlier. Paul conceded that those particular funds were excluded property. In 2021, this was sometime after Paul and Joanne's relationship had broken down, Joanne resigned as trustee of the trust and director of a related company. And Mr. Muster's evidence on this point was that he wanted to distance Joanne from the trust and the company given the litigation. Of course, Paul took a different view, and I expect Georgia will speak a little bit about that. Mr. Muster's evidence also included that he considered the assets of the trust to be his property to deal with as he saw fit during his lifetime. And Joanne gave similar evidence at the trial. There was also evidence from the solicitor who drafted the trust and from another lawyer who provided opinion evidence about the nature and interpretation of the trust. And so with that, I will turn it over to Georgialee.
Thank you, Gordon. All right, so To understand the context of the Cottrell decision, you need to first understand the principles that are now in the Family Law Act with respect to discretionary trusts and trust property. The starting point is Section 84 of the Family Law Act, which defines family property as including, quote, a beneficial interest of at least one spouse in property. So that is the starting point. That's Section 84(1). Section 84(3) says this, that family property includes that part of trust property contributed by a spouse to a trust. So for a trust interest to be family property, the starting point is that trust property has to be contributed by a spouse. Now, at the outset, with respect to the Cottrell case, you've heard Gordon tell you that the settlers of the trust were Ms. Cottrell's parents with their lottery winnings. And so that's the first criteria. The second criteria is that if the spouse is a beneficiary and has a vested interest in part of the trust property, that would also make the trust property or the interest in the trust rather family property. Or if the spouse has the power of appointment to transfer to himself or herself that part of the trust property. And finally, if the spouse has power to terminate the trust and transfer the property to himself or herself. So the indicia then of a discretionary trust interest being family property is a contribution by a spouse to the trust. The spouse is a beneficiary and has a vested interest. The spouse has the power to transfer property to himself or herself, and the spouse has the power to terminate the trust. Now, you've heard Gordon's recitation of the facts. And so the court found that Joanne's interest in this trust under the section that I've just quoted, or rather actually under Section 85, which talks about excluded property, that it was excluded property. Her interest in the discretionary trust was excluded property because she didn't contribute the funds to the trust. She was not a settler of the trust. And of course, at the time of the parties' marriage breakdown, she was no longer a trustee. But in any event, had she been a trustee, she was one of three trustees. And her father's evidence at trial was very clear that it was his money and that he controlled the trust. However, the court noted that pursuant to Section 84(2), any increase in excluded property may qualify as divisible family property. And that's where the analysis becomes interesting, because the issue before the court was the conceptual difficulty of reconciling an increase in the value of a discretionary interest in a trust as family property alongside the well-committed notion that beneficiaries have no rights in discretionary trusts or the assets of the trusts. And of course, in this case, Joanne had no ability to compel any of the trustees to transfer property to her. What Justice Brongers did was he analyzed Mr. Cottrell's claim in this discretionary trust by reference to, of course, the provisions of the Family Law Act that I've just summarized for you. And he stressed that the sections had to be addressed conjunctively, and that when read conjunctively, they provide that only the increase in value of the spouse's beneficial interest in property held in a discretionary trust is family property. So the provisions do not state that an increase in the value of the actual property held in the trust is family property. And Justice Brongers concluded that given the uncertain nature of Joanne Cottrell's interest, her contingent beneficial interest, it could not be said that at the time of trial there was any increase in the value of her discretionary interest. Now, Mr. Cottrell provided valuation evidence. Of course, his position was that there was an increase in the discretionary value to Ms. Cottrell. And what he did was he had, of course, through the course of the production of documents, he had the most recent financial statements for the corporation, and he had documents from the trust. I presume he had trust statements of account and tax returns. And he was able to suggest to the court that there was a significant increase in the value of the property, and that that property could be valued and should be valued, and that he was entitled to an interest. However, the court disagreed with his suggestion that by valuing the property in the trust, that was the value of the discretionary interest in the trust. And of course, that proposition is well established. And in fact, there are a couple of Ontario cases that are interesting. In one case, for example, in Dillon versus Dillon, which is a 2014 decision of the Ontario Supreme Court, the court looked at a discretionary trust, and relying on Donovan Waters' treatise on the law of trust, made a definitive statement and said that an interest in a discretionary trust is not capable of quantification. Now, I haven't seen that kind of bold-faced statement in the BC cases, although perhaps Gordon has. But the Ontario court came right out and said that. And other way, the Ontario court, whose legislation is slightly different, got around that in one particular case. And this is the case of SAGL, S-A-G-L versus S-A-G-L, SAGL, where the parties were in court and there were submissions being made about a discretionary trust under the Ontario legislation. And the husband, again, rather the wife, valued the trust by valuing it at its current value, mainly valuing the trust property. And as a compromise, the husband's lawyer suggested to the court that in order to resolve this issue based on principles of fairness and equity, that the husband would agree to value his interest in the trust at the date of the marriage, which was some 23 or 4 years earlier. And on that analysis, the court accepted that. And on that analysis, the wife did receive just over $1 million, although the current value of the trust was about 30 million. Now, I point out that that case has never been followed, and it was a bit of a creative way on the part of husband's counsel to provide a solution. And frankly, I think that had that solution not been provided, I don't think Ms. Sagel would have received any interest in that trust. So that's what the analysis is. And like Gordon noted, the discretionary trust is a hope and hopefully a promise of something. But because it's not definitive, and because trust property is not considered family property unless there's the certain circumstances, the criteria that I reviewed are established. That means that for the most part, a discretionary trust is a very good way to prevent an adult child who is a beneficiary from having to share that interest with a separating spouse. Thank you, Tina.
Thank you so much, Georgialee, on that. Up next, I'm going to do a demo of Lexus Plus. I'm just going to share my screen here. Just give me one moment. Okay, so Lexis Plus Canada is this amazing platform where, it will help you do some case research. And the fact that we actually already know what the case name is, Cottrell versus Cottrell, we can easily find that case by inputting the name. But what I'm going to show you guys is how to do a search by just using specific terms. So I would go under legal research, and what I'm going to type in is family law and discretionary trusts. Okay, and before I hit enter, I can actually make my search specific to all jurisdictions or British Columbia itself, but I'm going to show you just doing it, the search by all jurisdictions first until we get to the next page. So as you can see on the left-hand side, you'll see filters on the left-hand side here that you can actually filter out to do your specific search. You'll see that there's 169 cases that do show up under family law and discretionary trust. So I'm going to scroll down and make it specific to British Columbia. So I'm going to click on the jurisdiction and court tab here, and I'm going to go under the province and click on British Columbia. I also know from the discussion we had about the case that the timeline of this case is a 2022 timeline. So I'm going to scroll down to the tab of timeline here and put it all the way down to 2022. I'm going to hit OK. Once I hit OK, you will see that now the case, there's 7 cases that are populated. And the first case is the Cottrell versus Cottrell case. So I can actually click on this case here automatically. And by filtering my search, I was able to get to the British Columbia court system and finding the case that I was looking for. As you can see on your left-hand side, you'll see search terms. Now, I typed in family law and discretionary trust, so you'll see that they both are color-coded to the specific words. And you can actually follow down this tree here to see which paragraphs have the specific words you're looking for. So say, for example, I'm looking for discretionary trust. I can scroll down here. I know that the blue highlighted sections are discretionary trusts. Now, if I want to save the specific paragraph and it applies to, say, my motion that I'm submitting, I can highlight it and then I would right click and click on annotate. And you can make any note you want. I'll just say DT for discretionary trust. I'll save that here. So now every single time I go through my case here, I can actually look on the right-hand side and see any notes I've made specific to this case, and it'll actually take me to the paragraph that I actually annotated. And as you can see here, it led me to paragraph 30, which is what I had annotated, and it's going to be highlighted and shaded this way when you click on it. Now, if I click on info, it'll actually give me the source information. It's a British Columbia judgment. And if I scroll back up to the top here, and you want to view this case more so without anything around the screen, you can actually put into reading mode. And there's this tab right here. You click on that and you would just see just the case itself, which is more easier to read if you don't want anything around the case. And you can actually increase the font size at the same time. Now I'm going to exit back out of the reading mode. And with this case as well, just bear with me here, it's just loading. And if I scroll back up to the top here, and I can actually make a folder and save this case in the folder. You can print it, you can email it, and you can download it. You can either download it as a PDF or a Word document and so forth. Now, say for example, I want to go back to my results. I can click on the tab here, back to results, and it will take me back to the main page now. And if I were to change any of the wording, I can always edit it at the top here. I can add words, I can take out words, and so forth. And also now I want to look at practical guidance with this specific topic area. I'm going to click on the left-hand side. There's 2 ways of doing it. I can either click on the filters and click on practical guidance. I'll show you both ways very quickly. And you can click on, say you're looking for a precedent. I'm going to click on precedents. And these are the couple of precedents that show up under the topic of family law and discretionary trust. Now, if I want to do the search the other way around, I will just click on the Lexus plus Canada tab at the top. And I can click on practical guidance, which is on your left-hand side of the screen. Now, I know that I'm looking for family law British Columbia specifically, so I can search by the practice area, or I can type in a certain area that I'm looking for. So I'm going to click on family law British Columbia. And you can search, like as I mentioned, the search terms, you can submit them at the top here, or that we also have topic and task that you can actually select. I'm going to select property here. And then on the left-hand side, you'll see filters that you can select from. You can select precedents that you're looking for, or articles, or a checklist. So I will click on precedents as an example, and I will click on financial disclosure schedule, assets and debt, sorry. So what happens is once you click on that, you will actually see a precedent that will populate, and you can actually download it once again, or email it to yourself. And that's how practical guidance looks like when you're actually looking for specific topics. And if I were to go back, I can actually even go back to wills and estates law as well. So same concept, I can go back to the main screen if I want to do that way, and click on wills, estates, and trust and estates, but British Columbia, specific to that province. And once again, it's the same concept. You will see the different topics on the screen here, or you can search discretionary trust, for example, and it will populate on the screen here. And then you can go back to Lexis Plus Canada, onto legal research if you have any further things you want to search. And you can also search on the main screen. You can actually search by the content type you're looking for. Say if you're looking for that specific legislation that Georgialee mentioned, say Section 85, you can do the search here as well. You just click on legislation and you can type in the section you're looking for, and then you can make it specific to BC law. And that was a short little demo of Lexis Plus Canada. I'm going to stop sharing now. And up next, we're going to have Georgialee discuss her views of the case. And then after her, Gordon's going to discuss his views of the case.
Thanks, Tina. So my assessment of this case is that with the introduction of the Family Law Act, there was a whole new conceptual framework of legislation under the family law legislation. And that was the introduction of the notion of excluded property. And so those of you that practice family law know that gifts and inheritances are excluded property. Now, it's not quite as simple as that, but this is not a discussion on excluded property, but it makes sense that this interest in a discretionary trust sort of falls into the expansion of excluded property in that it's something that a spouse who is has a beneficial interest does not have the right or the ability to have that property to him or herself. And so the whole notion of inheritances, gifts, discretionary trusts all seems to blend in with the new conceptual framework under the Family Law Act. And of course, it's always been a very thorny question as to how those kinds of things are dealt with. Under the Family Relations Act, a gift or an inheritance was considered something that could be unequally divided, but it would really depend on when the gift or inheritance was received, what use was made of that money during the relationship. And so all of that is now old law. And the new law is what you see in the Family Law Act. And of course, from a family law lawyer's perspective, adult parents who benefit their children want to benefit their children, but typically they don't want to benefit their children's spouse if the marriage breaks down. And as in the Cottrell case, Mr. Cottrell had lots of benefits from these trust distributions to his wife during the marriage. And Gordon described the amounts of money that were received over a period of time. But that was when they were together and happily married. And so the notion is that once that marriage breaks down, that both the spouse with the beneficial interest and more importantly, the settlor, usually parents or some other relatives, want to make sure that those funds are protected. And I think that's a legitimate interest to that class of persons. And so I think I'll turn it over to Gordon to get his views on this case and how it impacts his practice area.
So I agree with much of what Georgia said there, as I will explain, but it also leaves me asking some questions that I want to explain that as well. And so I think the result makes sense when you consider that Joanne could not effect a distribution from these trusts to herself, and that interest could theoretically be defeated in any number of ways or rendered valueless. So Mr. Muster could have distributed everything to himself. Everything could have been distributed to the brother. He could have removed Joanne as a beneficiary. Her entitlement could have somehow be reduced, or she could have died perhaps before Mr. Muster and ultimately received nothing from the trust. And so, yeah, theoretically, there's no guarantee that her portion of the trust has grown in value at all. It's still merely a hope. However, when you look at the family relationships and the history of the distributions, albeit from a previous trust, was that really the case? I'm asking myself. I mean, Mr. Bronger or Mr. Justice Brongers certainly thought so, but he didn't need to rule that way. And I think credibility played a big role in the outcome of this case. And what I mean by that is Justice Brongers accepted Mr. Muster and Joanne's evidence about their intentions and expectations with respect to the trust. Paul presented a different narrative about Joanne resigning as trustee and it being a conspiracy to keep him from accessing these trust funds. If Mr. Justice Brongers had not believed Mr. Muster and Joanne, I think the result could have been different. But he believed that these trusts, or believe is probably the wrong word, he held that these trusts were truly discretionary rather than being discretionary in name only. And there are other cases where, quote unquote, discretionary trusts have been found not to be truly discretionary because the intentions and expectations of the interested parties are different from what they were in this case. Justice Brongers did leave open that a different conclusion could be reached on different facts. He said, my finding is based on the evidence presented in this case, particularly the terms of the Muster Trust instruments, as well as Mr. Muster and Joanne's testimony about their intentions and expectations regarding these trusts. And that's what goes back to the credibility part. Of course, there will be further cases dealing with this issue, and perhaps appellate guidance will be necessary before there's any certainty on this, or at least a definitive structure about how to approach this difficult issue. Just a couple final points. I do note that these cases do not seem to come before the BC courts all that often. In some ways, it's not surprising because they typically involve wealthy families who I expect place value on privacy as opposed to being keen to litigate these matters in open court where the history of the family finances, their management, tax planning, etc., would all become part of the family record. And so as other commentators have noted, many of these cases do settle, and that probably will continue to be the case. One final note is related to Section 87 of the Family Law Act, which states that the value of family property must be based on its fair market value. And so that's what the court's attempting to determine. What's the fair market value of the spouse's beneficial interest in this trust? And I just wonder how a court can ever really determine the fair market value of a beneficial interest in a discretionary trust, particularly in a family trust context. Like, surely no outsider to the family would ever pay money to purchase that interest in the trust because they're never going to receive a distribution. Who, in a family trust context, an outsider, like how would they ever receive a distribution? And so I question the applicability of fair market value in this context. And I wonder if there might be other ways of approaching what fair market value means under Section 87, at least as it relates to discretionary trust. One approach that has been suggested by a commentator that I read is, what is it worth to the beneficiary to pay to keep their interest in the trust? Also a very difficult concept to apply, but perhaps a better indication of its actual value. Those are my comments.
Thank you, Gordon. Okay, up next, we have our poll question. I hope everyone was paying attention, as Georgialee did hint the answer to this question. So let's pull up that PowerPoint on the screen. Okay, so what section of the Family Law Act provides that any increase in value of a beneficial interest in property held in a discretionary trust does not include the value of any property received from the trust? We'll give you guys about a minute. Okay, I think everyone is pretty much done here. Let's see what the outcome of the poll is, the poll question. Okay, so we see that majority of people did vote for section 84.3. The correct answer was 84 subsection 2.1. Sorry, actually I was wrong. Majority of people did pick the correct one, but it's section 84 subsection 2.1 of the Family Law Act. Great job, everyone. Okay, so now we're actually going to go through a couple of discussion questions. We will leave some time for everyone who has questions for us to, message it into the chat right now. But we'll start off with question number 1.
Tina, before you do that, can I make a comment about section 84 2.1?
Yeah,
The
go ahead.
whole question you did?
Yeah.
In the Cottrell case, I looked for a reference to that section. And Gordon, I don't know if I'm correct, but I didn't see a reference in the Cottrell case.
I think you were right.
Yeah, and if you look at the language of that section, 84 2.1, the section reads as this: any increase in value of a beneficial interest in property held in a discretionary trust does not include the value of any property received from the trust. I'm not sure I know what that means. Gordon?
I
what do you mean? I mean, so she received property from the trust. I get it that that's not included because it's spent. And anything she received that was put in her own account would be excluded property. But I'm really curious as to what the legislators had in mind, the legislators had in mind with section 84.2.1. And I thought it was noteworthy that I searched for it in the Cottrell decision, and I don't think it's in there.
And I'm interested to see how in the future this section might be cast aside or differentiated with, like, the history of contributions from a discretionary trust may not be included in the value, but that like the history is part of what people's expectations and intentions are with respect to a trust. And so the history cannot be ignored, I don't think, in trying to value this interest. And so I'm interested to see how that plays out.
Yes, and Gordon, in the earlier cases under the Family Relations Act, that history of distribution of trust assets was very significant. Sorry to interrupt, Tina, but I just thought this was such an interesting point.
No. I think it's good to actually discuss it, because when you do read it, it kind of seems like, how does that make sense? So I totally understand that. Okay. We'll do the first question here, and either Gordon and Georgialee can answer this. When will an interest in a discretionary trust be characterized as family property pursuant to the Family Law Act?
Do you want me to take that, Gordon? Okay. Well, it will be declared family property if the spouse was a settlor or a contributor of the trust property to the trust. If the spouse has a vested interest in the discretionary trust, that could make it family property. If the spouse has a power of appointment, and if the spouse has a power of termination. So all those privileges in relation to a discretionary trust, which gives the beneficial discretionary beneficiary some power and control, that could turn it into family property.
Thank you so much, Georgialee, for that. Okay, the next question is, in Cottrell, Justice Brongers took care to say a different conclusion may be reached on different facts. What different facts may have changed the outcome and why?
So I'm happy to start on this. I expect Georgialee may want to opine as well. I think obviously contribution by Joanne would have changed things, but that just wasn't the factual matrix. But just considering these, the situation they were in that case, control, I think, was an important factor, and that related to credibility in this case. If Mr. Muster and Joanne had not been believed in terms of what their intentions and expectations were, I think, and the court concluded she actually had control or had more control than what her evidence was, that may have changed the decision. The court could have taken a more sinister view on why she resigned as trustee. A greater history or more recent history of distributions from the trust. We had the history of distributions from the previous incantations of these trusts, but if this had been continuous to the date of separation, or there was evidence from her or Mr. Muster that, yeah, they did have an expectation that she would receive, and that was common knowledge in the family, that could have changed the decision. And so I think council did a good job of controlling that narrative in this case. Just a couple other points, perhaps some different evidence on the increase in value of this beneficial interest in the trust may have assisted, though perhaps not in this particular case, but just an expert opinion on the value of the beneficial interest based on the history and a number of other factors, which would be a very difficult task for evaluator, I expect. And lastly, I just wanted to point out, Madam Justice Francis, before she was appointed to the bench, wrote a paper with another author, co-authored a paper, and argued, this was several years ago, that courts will look beyond the trust instrument to matters of control, use of trust property, and historic distributions to the beneficiaries, and in doing so will seek to assign a value to discretionary interest based on fairness principles while protecting against the punitive result of a spouse being forced to pay for an interest they will never realize upon. And so that's a good summary, I think, of the difficult tasks the court has. And I think this balance, or trying to achieve this balance, which is very discretionary, will inform the analysis moving forward.
Perfect. Thank you, Gordon.
I think Gordon covered that pretty well.
Yeah, I was gonna say.
Yeah.
Okay, the next question deals with Section 87 of the Family Law Act. It states that the value of the family property must be based on its fair market value. How might the courts determine the fair market value of a spouse's beneficial interest in property held in a discretionary trust?
Well, let me just say that I agree with the decision in Dillon from the Ontario Supreme Court that it cannot be valued. It's a hope. It's a promise that may or may not come to fruition. I don't think you can value an interest in a discretionary trust. You can value property in a trust, but that is not what the spouse owns or has an interest in. And I welcome any other comments from Gordon on that topic.
I think the family law seems to demand a value, some sort of valuation, and I guess the value will be zero in a lot of cases. But I mean, I have read some concepts about, fair value, what is just and equitable in the circumstances, looking at all of the factors, which sort of run afoul of black letter trust law, but may help achieve some of the goals of the family law. Or what I spoke about earlier. I mean, like, is it possible to understand what a spouse would be willing to pay to keep their interest in the discretionary trust and try to assign a value from that perspective? Doesn't make the question any easier, I don't think. I just think it's a different and perhaps more appropriate question than what is fair market value.
Okay, perfect. The next question we have is, either one of you guys can answer this. In your view, why did Justice Brongers not place weight on the distributions to Joanna from earlier trusts settled by the parents?
Well, the reason he didn't is because he was following the legislation, and that's simply not a factor. The fact that she'd received distributions during the marriage doesn't have any bearing on what her interest in the discretionary trust is at the breakdown of the marriage. And of course, the Family Law Act is clear that family property is valued at the date of separation. And the other aspect of this, Tina, is that contribution is no longer a factor in family law. It was under the Family Relations Act. Contribution was a significant factor, but contribution has been taken out of the Family Law Act. So that's why it was not a consideration, and appropriately so.
Perfect. Thank you. Georgialee and Gordon, we actually have a question from the audience. The question here is, does it require the spouse to have contributed to the property? Wouldn't it be family property in the circumstances of A to C, even if the spouse didn't contribute? And I think she is referring to Section 84.3 of the Family Law Act.
I can take that question. If the spouse has contributed to the property in the discretionary trust, then that is one of the criteria to declare that interest family property. However, the law is very clear that if the spouse did not contribute to the trust, is not a settler of the trust, then that property, that trust is not family property. So it's as simple as an examination of the legislation.
Yeah, that's my understanding as well. I'm just reading the section now, and it in the before it gets to A to C, it says family property includes that part of trust property contributed by a spouse to a trust in which, and then lists A through C. And so I think George is right on that.
Okay, perfect. Thank you so much. Okay, so another question we have created was in respect of expert evidence. What is your view on the use of lawyers' expert evidence interpreting the trust? And the second, we'll do that question first, and then we can do part B to that question.
Well, of course, the court dealt with that in Cottrell because the husband who was seeking an interest in the discretionary trust produced an expert report from a wills and estates lawyer providing all of the details about what a discretionary trust was, how it plays out, what the indicia of a discretionary trust are. And interestingly enough, the lawyer for Ms. Cottrell didn't object to the admissibility of that report, but the judge rightly pointed out that judges are expected to know the law. And this is domestic law. This is the law of discretionary trust in British Columbia. And that's what judges are there to do, is to interpret it. And so the judge actually referenced a decision from the BC Supreme Court, Walsh versus BDO Dunwoody, where the court refused to admit expert evidence, where the evidence was used to educate the court on the interpretation of domestic law. And what Justice Brongers did, he said, because this wasn't objected to, it was admitted, but I make it clear that I'm not relying on this expert opinion. I'm relying on my own findings independent of the expert's evidence. And so I think that I can understand why counsel would think that was necessary to just to buttress their case, to have an expert say, here's all the details. But clearly it's contraindicated. That's what judges are supposed to do, and counsel are supposed to bring case law to inform the judge of the state of the domestic law.
My one comment there is I agree with everything Georgia just said, but as a tactic, you know, it worked. She did win. Was it necessary? We don't know. But, you know, we know the judge heard it from the expert witness in testimony, heard it again in closing, and then ultimately accepted those views. Was that necessary? Probably not. I mean, from a cost perspective, it probably just could have been incorporated into the closing submissions. But I just note, as a tactic, it did, you know, she was ultimately successful.
Mm-hmm.
So we have time for one more question, and we have one more from the audience. The question is, if parents buy a house for a child, but register a mortgage for 100% of the value, and parents will forgive the mortgage debt, would that create an interest that could be attacked by the child's spouse prior to parents' death? What about if child was making mortgage payments to the parents?
Well, that's interesting. I just had a case like that. That we actually settled in arbitration, because that was the issue. There was a house and it was in joint tenancy between a spouse, a female spouse, and her mother. And what her mother did was she gifted a half of the interest to her daughter, but she also placed a mortgage on title that was equivalent to the value of the gift. And there was all kinds of discussion about whether the mortgage was legitimate, whether this was actually a gift. And this case did not go to court. but it was a very difficult question to sort out. And the other thing that was interesting about this case that was just resolved was that the mother imposed a very high rate of interest. So by the time this marriage broke down, with this debt, this mortgage on title, the mortgage, which was for about $500,000 at the time the gift was made, was now $1 million. And so the fight was on as to whether that was legitimate, whether, and like I said, it was resolved in arbitration. I think it's difficult to say what a court would do, but those issues certainly come up in family law.
Perfect. Thank you so much. I think that was a great answer because it can get very complicated. Does anybody else have any other questions? I actually just wanted to go back to the question about the expert evidence that we were speaking about. Just one last question. What other expert evidence could have been adduced to value the increase in the discretionary trust interest? Would it have even mattered?
Gordon, why don't you take that?
Sure. And so I think what the court in Cottrell alluded to the fact that it would have been helpful, I think, to have I don't think they used the word valuator, but a valuator to try to value the interest, the beneficial interest in a discretionary trust. But that must be an incredibly difficult job for a valuator to do. And I imagine two different valuators would give perhaps very different opinions. And I think that if you obtained expert evidence, which I guess you're supposed to do in a case like this, to value that interest, it would be very open to attack on the assumptions that you provide to the expert to reach the opinion. And so I imagine it would turn into a whole fight.
Yeah, and let me just add one point. Under the new rules, family law counsel are required to appoint one joint expert. So it would be very interesting. The fight would be on who is that expert going to be. And of course, if the council can't agree, the court would decide. And the idea of critiques on expert reports are held in distinct disfavor now because the court is getting away from the battle of the experts. But that just a practical point to add on to Gordon's very succinct answer.
Perfect. Thank you so much to both of you guys. I think that's all the questions we have for today. And we've actually neared the end of our webinar. I want to thank both Gordon and Georgialee for speaking at today's webinar and everyone that attended. We hope that this was a helpful webinar and we hope to see you guys again.
Thank you, everybody.
Yeah, thanks, Tina, and thanks everybody.
Thank you so much.